Good afternoon, everyone. Good afternoon. My name is Steve Channinson. I'm the faculty director for the David F. and Constance B. Girard-diCarlo Center for Ethics, Integrity, and Compliance. Thank you all very much for joining us this afternoon as we hold our annual Gold Lecture on legal ethics and professional responsibility. We're honored to have with us, as always, the Gold family and also Michael Stein for support, and thank them for supporting this lecture. And we have a real treat for ourselves this afternoon. We are thrilled to welcome Erika Harold, who is the Executive Director of the Illinois Supreme Court Commission on Professionalism, who will talk to us today about bullying in the legal profession. Ms. Harold is a graduate of the University of Illinois, as well as Harvard Law School. She was a commercial litigator at several firms in Illinois, both in Chicago and downstate, before taking on her position with the Commission on Professionalism. When she talks to us today about the role of bullying in the legal profession and how to prevent it, as you will hear, she is speaking about a topic that has long been important to her and one on which she has long been a national leader. The Commission's study that is linked in the materials that you've seen and will be also on her PowerPoint reflect what we believe to be the first widespread survey of attorneys, more than 6,000 in Illinois. And the results, I think, will shock you. They certainly shocked me. So, the plan today is to hear from Ms. Harold, and then there'll be some time for questions and answers. I will be your microphone guy running back and forth, so don't hesitate to ask questions. For those of you who are here in part for CLE credits, you should have received a form on the way in. Please make sure that you deposit your completed form in the basket at the registration table. And with that, please join me in welcoming Erika Harold.
Well, thank you so much for inviting me for that introduction, and a special thank you for everything that you do to advance ethics and professionalism. Just in preparing for this lecture, getting the opportunity to hear about you, your background, and your personal commitment to advancing ethics, and the courageous way you do that has been very inspiring. I've also been really enriched by learning about the David F. and Constance B. Girard-diCarlo Center for Ethics, Integrity, and Compliance, because I think that mission is so vital to our profession. It's so vital to the most important elements of our legal system. And when I was reading about the work that's done, the mission and the vision, it aligned so much with the Commission on Professionalism. I've also been particularly inspired by learning about Louis Gold's legacy. In reading about him, I saw that someone wrote, quote, "Lou was a mentor, a friend, a champion for all, and a remarkable advisor. Words cannot express how much he will be missed by his family, his friends, and professional associates." And this was the part that really struck me. Once in a lifetime, a person as special as Lou comes along, and we feel very lucky that we shared a brief part of life's journey with him. When you think about a legacy, if someone would say that about you, you can't ask for a greater tribute. And so to be able to give a lecture in the honor of someone who has made that kind of an impact is truly an honor and a privilege. Please give the Gold family one more round of applause. Now we'll see if I can work this PowerPoint. Today's presentation will focus on three things. First, the why that led to the undertaking of this study on bullying in the legal profession. Second, the data that the study uncovered. And third, the recommendations for preventing bullying in the legal profession. And the recommendations will really talk about the courage that's needed to actually make an impact. So often we know about what needs to happen. We can all identify what needs to happen. But if people don't exercise the moral courage to actually do the things that need to happen, then our recommendations are mere words on a page. And the last thing that I would be proud of is if the commission created a beautiful study that people said, well, good for you, and did nothing. And so my hope is that you will leave and do at least one courageous thing that will make a difference. To me, that's the beauty and the purpose of having a study. Now, I've been involved in bullying prevention efforts for more than 20 years, and my why is both personal and professional. The catalyst for my experience was my own experience being bullied when I was in high school. When I was a freshman, I was the victim of pervasive and severe racial and sexual harassment. It started out with name-calling, teasing, taunting. It escalated to vandalism of my family's home. We had to call the police to our home multiple times during that year. Ultimately, it escalated to death threats, and the administrators were not able or willing to take sufficient steps to protect me. And I'm not going to say the words that I was called, but they are words that probably you're familiar with from your own experience in school. And I can tell you the impact of those words was it made me feel like I almost wanted to become invisible. Instead of going to school wanting to make an impact, wanting to answer questions, I found myself sitting there wanting to be invisible. One of the things the students would do is play this game that they called the uncool game, where they would sit there with pieces of paper on pads and write down every single thing that I did during the course of the class period. So if I raised my hand, they would write it down. If I coughed, they would write it down. And this persisted for the class period. And then at the end, the teacher would allow them to stand up in front of the rest of the class and read aloud that list of all of the, quote, uncool things that I had done. And I was just sitting there almost wanting to be invisible. And I remember the administrators said, when I kind of reported this behavior, they said, you need to be very careful accusing someone of harassment, because 20, 30, 40 years from now, they will always have to live with the pain of what it felt like to be accused of harassment. I'm sure you can imagine what I was thinking. 20, 30, 40 years from now, I will remember what it felt like to be subjected to harassment and to not be viewed as worth standing up for. So after this persisted for more than a year, I ultimately made the decision to transfer to a different high school. It was a difficult decision because on some level, I felt that I was abandoning a fight that I should keep fighting. But I recognized that I needed to be in an environment that was safe. And so I decided to transfer to a different school, and I had a much better experience. But that experience of feeling powerless is one of the catalysts for me becoming an attorney. I wanted to be able to acquire the skills to not only be able to advocate for myself, but to also be able to advocate for other people. And I also committed to myself that if I ever had an opportunity to be able to make an impact on the issue of bullying, that I would do so. That would be my way of being able to stand up. Now, that opportunity came unexpectedly when I was crowned Miss America 2003. I will not tell you all of the path that I went to get there. During Q&A, if you're interested in the story, I'm happy to share that. But as a result of becoming Miss America, I was able to make preventing youth violence and bullying my national platform. I was able to speak to more than 100,000 young people about standing up for their peers and being an ally. I was able to partner with wonderful organizations like the National Center for Victims of Crime to create a bullying hotline that kids could call if they were being bullied, no matter where they were in the country. And I also partnered with PBS. We did an episode from their Emmy award-winning series In the Mix, focused on what kids could do to protect themselves against bullying. And it was really impactful to be able to see that when you talked to young people about exercising moral courage, that they were willing to do so. But after becoming an attorney, I was really disheartened to see that so many of the behaviors that I had spent time telling young people were unacceptable were behaviors that were pervasive within the legal profession. Bullying behaviors such as insulting people, calling them names, screaming at them, threatening them that you would do something to them if they didn't do unethical things. And I was struck by the fact that our standards in classrooms for kids were higher than the standards that we have for lawyers in courtrooms. And that was deeply troubling to me. And so I realized that I had an opportunity to take on this issue when I was appointed to be the executive director of the Illinois Supreme Court Commission on Professionalism. This is a commission that the Illinois Supreme Court created to be able to promote integrity, ethics, and inclusion and civility among Illinois lawyers and judges. And I'm incredibly grateful that the Illinois Supreme Court has wholeheartedly embraced and supported this topic and this initiative. I don't know that every state court would be willing to do this. And so now I want to tell you about the study and what we found and what we can do about it. After I was appointed, I thought we need data to find out how prevalent bullying is in the legal profession, and then to be able to find out, can we quantify the impact of this behavior? And as it was said in the introduction, this is believed to be one of the first wide-scale research projects in the US on this topic, and we enlisted the Red Bee Group to undertake the research and author the report. The survey defined bullying as inappropriate behavior intended to intimidate, humiliate, or control the actions of another person, including verbal, nonverbal, or physical acts. And we were able to get an excellent sample size. More than 6,000 Illinois lawyers responded to the survey, and then we did 10 focus groups with a range of participants from a range of backgrounds. And because of the survey's large sample size, the report's findings are instructive for lawyers and legal organizations nationally. Before I share the findings, I do want to briefly comment on what distinguishes bullying from incivility and what distinguishes bullying from harassment. Because people might wonder, well, aren't we just talking about incivility, or aren't there already rules that address harassment? The reality is that bullying fits within a gap, both in law and policy, which makes it urgent to address it. The main distinctions between incivility and bullying center on intent, targeting, and frequency. While incivility may or may not be targeted at a specific person, bullying is abusive behavior that is targeted at a specific person. It's intended to humiliate or control them. Whereas incivility may not have a specific intent, it may be something that might be generalized rudeness. And acts of incivility might happen once or twice. Bullying is usually repeated over time. But unchecked incivility can foster the types of conditions that lead to bullying and harassment, because behavior that's allowed to persist often operates on a continuum and escalates. I'm sure you can think about that in your own lives. The main distinctions between bullying and harassment center on protected characteristics. Harassment is bullying that's targeted at someone based on a protected characteristic, such as race, gender, while bullying is not motivated by a protected characteristic, or someone may not be able to prove that the reason they were targeted is on the basis of a protected characteristic. So why does that distinction matter? Well, harassment policies and harassment laws already exist, but it may surprise you to know that bullying in the workplace is not illegal. So if you're bullied repeatedly but can't show why, and can't show that it was a protected characteristic, you may not have a remedy or recourse in law or based on your particular organization's policy. So what did we find in our research? First, we found that 1 in 4 lawyers were bullied in the course of a year. We did not ask people about the entirety of their career. We wanted to get a 1-year snapshot to make sure that the data and the experiences that we were getting were new. What people also did is not only respond to the questions, but they could write in quotes. So throughout, I'm going to share with you some of the quotes that Illinois lawyers wrote. One person wrote, "My senior partner treated me in a pathologically harsh manner." Another person wrote, "Bullying permeates throughout the legal culture, especially in courtrooms and with the judges. It is embarrassing to the public perception of the legal system and is completely contrary to the concept of access to justice." Once we looked at that 1 in 4 number, because we had such a wide sample size, we were able to break down the data based on different demographic characteristics. And this finding probably does not surprise you, but bullying disproportionately affects traditionally underrepresented groups. We found that as it relates to gender, 38% of female lawyers were bullied at work in a 1-year period, as compared to 15% of male lawyers. We looked at disability. 38% of lawyers with a disability were bullied in the past year, compared to 23% of lawyers without a disability. Age played a very significant aspect. 39% of lawyers aged 25 to 35 were bullied in the past year. And what we found was that lawyers in this age group were more likely than others to report that they had been bullied. The research also found that the likelihood of being bullied decreased for each increasingly older group of lawyers. With respect to sexual orientation, 29% of gay or lesbian lawyers were bullied in the past year, as compared to 25% of heterosexual lawyers. And here are some quotes from lawyers who wrote specifically about those types of experiences. One person wrote, "I left the last 2 legal aid agencies because of bullying and lack of ADA accommodations." Another wrote, "Aggressive, mostly older lawyers intimidate younger or newer ones and use it as a legal tactic." Another person, "The chief executive regularly threatened, intimidated, and belittled me generally, in private and in person. He also did the same specifically based on my sexual orientation, but did that only in private." And female lawyers reported being subjected to shouting, insults, and being called demeaning names, such as the ones that are up there. The research also showed that lawyers of color were bullied more often than white lawyers. In the past year, 36% of Middle Eastern or North African lawyers were bullied. 35% of Black or African American lawyers were bullied. 34% of Hispanic lawyers were bullied. 32% of multiracial lawyers were bullied. 28% of Asian American lawyers were bullied. And 23% of white lawyers were bullied. There are 2 things to take from that data in particular. One is that certain groups of people are disproportionately targeted. But 2, regardless of someone's background, they are not immune from being targeted. And so this is an issue where everyone is impacted. Everyone could be bullied at some point in time. And it shows that addressing this issue could improve the climate and the profession for everyone. One person wrote, "In an employment evaluation, I was described as a, quote, angry Black man who didn't get along with colleagues or clients." Another person was told, "You're very articulate. You have no accent," as if the way to be articulate is to not have an accent. Another person wrote about the biases and stereotypes that are prevalent. One question that you may be wondering is, so who is the bully? What we found, you can see on the screen, when people were identifying who were the people who were the most recent bullies, 33% said it was a lawyer outside of their firm and company. So that would be something like opposing counsel, bullying them in the courtroom or in the context of a negotiation. 23% said a lawyer in their firm or company who was more senior to them. Interestingly, 14% said that the bully was a judge. Another 8% said that the bully was a high-level member of their firm or company. 7% said it was a client. This data is really interesting because it shows that there's not a one-size-fits-all solution that will work. What you would do in the context of your own firm or your own organization is really different from what you might do if you were being bullied by a judge. The power dynamics, the governing rules are completely different. And so looking at the specific ways in which power is leveraged and abused is essential to being able to really start to get to be able to make an impact on this issue. Once we asked people, have you been bullied? We wanted to know what was the specific behavior that you were subjected to. And when this definition was put together, we also recognized that some of the behavior, to some people, might be debatable. They might say, well, is that really bullying? But part of what we wanted to do is to provoke a debate about the contours of acceptable behavior. If someone was saying, well, I think it's okay to be harsh or belittling to another person, I want to have that conversation. Why do you think that that's an okay way to treat someone? Why do you think that's the most effective way to treat someone? So what we saw was that the most commonly experienced types of bullying were verbal intimidation, such as disrespectful speech, insults, name-calling, shouting. Then harsh belittling or excessive criticism of work. Then demeaning nonverbal behaviors, such as eye-rolling, finger-pointing, staring. Routinely being subject to unrealistic deadlines or other unreasonable work demands. Now, we recognize that some people will say, well, that sounds like every lawyer's day, being subject to unrealistic demands. That was not intended as a laugh line, but I see we have a lot of lawyers here. But the reality is, if you have differing standards for people, if you have certain deadlines for some lawyers, but then more reasonable ones for others, what you're doing is treating people in ways that are discriminatory. You're also setting some people up to fail. I'm sure many people in this room can think back to an experience where you were given a task to do and you thought, I'm being given this task because this person doesn't want me to actually be able to accomplish it. They're actually sort of hoping that I fail. Those sorts of acts of sabotage are bullying and have impacts on people. Then behind the back false accusations and malicious rumors. Someone improperly taking credit for your work. Not receiving opportunities and work information that you would ordinarily be given access to. When you look at these, you can see how some of these you would be aware that it's happening to you. You'd have the opportunity to be able to defend yourself, to be able to advocate for yourself. But some of these others, the ones that may seem more subtle, you may not realize that they're happening until after you've already been passed over for a promotion, after you've already been iced out of a situation. I would also note that other types of bullying behaviors that Illinois lawyers reported include cyberbullying, physical intimidation, such as throwing objects, invading space, and stalking, and physical contact, inappropriate touching, pushing, or shoving. Now, those did not make the top 7, but I do think they are important to note because we're talking about criminal conduct that has a very debilitating effect on people who are subjected to it. So what's the long-term impact of this kind of bullying on lawyers? 54% of lawyers who were bullied reported a negative change in emotional well-being after being bullied. 39% said that they felt less productive at work. And then this next statistic is the one that surprised me the most. And this statistic was based on the entire trajectory of someone's career. 18% of lawyers reported that they left a job practicing law due to bullying. And so when you were hearing about the topic of bullying, most people associate it with kids. And they think, does this really have any impact upon adults? If you think about the legal profession and lawyers and how oftentimes risk-averse lawyers are when it comes to changing a job, it takes something dramatic for people to say, I'm going to leave an environment. And for someone to decide, I'm going to actually take the steps to leave a job and find a new one, that tells you how that level of toxicity is impacting them. What this data has also been able to help us do is to advocate for change. Because I think that there's an ethical and a moral case for taking action on these things. And I think that should be sufficient. But I also recognize for some people that won't be enough. They will want to look at productivity and dollars and billable hours, and that will be the metric that most motivates them. And so if you know that you're in charge of a law firm and productivity is going down based on lawyers being bullied, or that people are leaving your firm and you're having to explain to your clients why there's such a turnover, that has an impact upon the bottom line. Looking at some of the other negative effects, lawyers talked about experiencing a decline in physical health. They talked about experiencing reduced opportunities to work on matters. They talked about losing out on opportunities. One lawyer wrote, "At my current job, the partner I report to appears incapable of acknowledging his role in creating the toxic workplace problems that exist. On a daily basis, this leads to increased staff stress, anxiety, and uncertainty." And then if you're asking yourself, how can bullying actually reduce productivity? I think this next quote illustrates that. Bullying compounds itself. After being bullied, you begin to worry. Then you have trouble sleeping. You come to work, but you aren't working at your full capacity. And then a quote that hit home for me because it brought me back to my experience in high school, almost wanting to be invisible. Bullying is a great silencer. Unsurprisingly, only 20% of bullying cases are reported to supervisors, firm leaders, or HR. Common reasons for not reporting the bullying behavior include not wanting to be perceived as, quote, weak or a complainer, fear of the bully's status, the belief that the employer would not do anything, and concerns regarding loss of work or loss of job. As one person said, and I think this captured many people's sentiments, if I said something, I might have lost my job. I feared possible repercussions. Many lawyers reported looking to judges for actions against bullying. They wanted to see judges proactively take steps to stand up for them. They viewed them as having power to disrupt a culture of bullying, especially in the litigation side. One person wrote, "A judge that makes it very clear from the first impression that something's about to happen, that they are not going to tolerate bullying in their courtroom, that makes a huge difference." Another person wrote, "Judges need to start sanctioning attorneys for inappropriate conduct." And then another person said, "Admonish the bully and report it if it continues." I included these next two quotes because we're at a law school and we were looking at where does this behavior start? And I thought these two quotes were really important. One person said that bullying starts with the hyper-competitiveness in law school and continues into the workplace. In your first job, everyone's asking, where did you go to school? As you're trying to kind of rank people and establish a competitive hierarchy. Another person wrote, competitiveness is baked into the legal profession from the time the LSATs are taken through the type of firm one works in. It's extremely hierarchical and perfectionistic, which lends itself to bullying behaviors. And I don't think that any law school is immune from these sort of competitive pressures, because the legal profession, it does attract people who are highly driven, highly ambitious, people who do want to make an impact for their career and their clients. But there have to be ways of being able to incentivize people without pitting people against each other. When you're in law school, the people that you go to school with should be the people that are your greatest source of support throughout the trajectory of your career. 10 years from now, you would hope they would be the kind of people who would recommend you for a case, recommend you for an opportunity. But if people are fighting against each other and feeling that it's a zero-sum game, it really makes people less likely to let their guard down. One of the things that I think is particularly troubling about that dynamic is that law school is stressful, and being able to have camaraderie of saying, I'm struggling too, or to be real and honest about mental health issues and mental health challenges that people are facing, you want to be able to share that without feeling that it would be weaponized against you or leveraged against you in some way. And at the commission, we're thinking through what programming might we create as it relates to law students, because the way people are taught and the different professional characteristics that we learn in law school as being foundational to the profession, if we can start to embed greater empathy and inclusion into how we are structuring curricula and the experience, I think we have a better chance of being able to impact the profession. So what were our recommendations based on this data? And I will go over them fairly quickly because I do want to make sure that we have time for questions. And I also want to make space if anybody wanted to share an experience that's important, because one of the things that's been such an honor in working on this project is having people be willing to share their own experiences. I think sometimes there's a great stigma to say, this thing has happened to me. People don't want to feel as if they are a, quote, victim. But when things happen to you that are not your fault, you should not feel stigmatized into silence. And so I want to make sure if there's anyone who wants to share anything, that they have the opportunity to do so. The first recommendation was to implement anti-bullying policies in all workplaces where lawyers practice. And not just a policy that says you should not bully. The policies need to clearly define what constitutes bullying. And some of the behaviors that we listed and identified in the report are good starting places. There need to also be concrete and meaningful remedial actions for engaging in bullying. This could run the spectrum, everything from mandatory training, reprimand, demotion, termination, or other financial consequences. Now, it might surprise you to think that we think that demotion and financial consequences should be attached to some of this behavior. But if the metric that we use for success is finances, and people are never subject to termination or loss of money or opportunities for this behavior, we will not be able to shift people's incentive structure. There also needs to be a requirement that there's an investigation of the allegations and a documentation of the results, and a strong prohibition against retaliation. And in the weeks following a complaint, part of making sure the retaliation isn't occurring is for someone to go back and follow up with the person and to ask a very, very specific set of questions to find out if retaliation is occurring. So it's not enough to say, is anyone retaliating against you? The question should be asked, what new matters have you been given recently? What work opportunities or work pitches have you been included in? And the reason why these types of questions are important is that there's the subjective concept of retaliation, but then there's the objective. If someone has been flourishing in their career, and then they make a report, and then all of a sudden, no one is giving them new matters, or they're not being given opportunities to compete in client pitches, that person is being iced out. That person's career is being impacted. It's important to know that existing anti-harassment policies that only prohibit harassment based on a protected class, they are insufficient because they won't encompass the spectrum of bullying that occurs that's not based on protected characteristics. Or it won't sufficiently protect people who aren't able to meet that burden of proof. Second, legal workplaces should conduct training specific to their organization's anti-bullying policy, with a real emphasis on who to report, how to report, and then bystander training. Some of the ways in which bullying can be disrupted is if the people in the room use the power that they have to be able to do something. And bystander training can be almost giving people specific scripts of what to say. If you see someone being mocked for an idea that they made, you don't have to say that behavior is bullying and violates this rule of professional conduct. It doesn't have to be that formal, although you could if you wanted to say something like that. But it could be saying, hey, I want to hear what that person has to say. You're deflecting, you're redirecting, and you're supporting the person in real time. Giving people very simple ways in which they can respond to situations where they feel uncomfortable but don't know exactly what to say that doesn't escalate, we think can be very valuable. Courts should also enforce anti-bullying standards in courtrooms and litigation activities. We think that prohibitions against bullying should be incorporated into standing orders. And this is for a very practical reason. First of all, it sets the tone, but what it does is it lets people know in the courtroom what to do specifically if they are being bullied during the course of a case. A judge can say, I will entertain this type of emotion if this kind of behavior is occurring. Again, so many lawyers will say, I know this behavior is wrong, but I don't know which rule it violates. I don't know how to bring it to anyone's attention. Standing orders really put some obligation on judges to be able to codify this. And I'm very pleased to report that it was the weekend after this report was released, I had a judge reach out to me over the weekend and say, just so you know, I've read the report. I'm working on updating my standing order right now so that it includes the language that you suggest regarding bullying. And I share that with you because seeing this data may make you feel that this is a problem that is intractable, but it's not. All it takes is a few individuals who decide, I'm going to use my power differently. There was a time that childhood bullying was viewed as something that didn't matter. People used to say, sticks and stones may break my bones, but words will never hurt me. And the idea that you should take seriously bullying in schools, people thought that's just kids being kids. But now there has been a paradigm shift. People recognize it's not okay to expect kids to go to school and to be targeted. I hope 10 years from now, we look back upon a lecture like this on bullying and say, well, of course, it's so obvious. Of course, lawyers shouldn't be able to weaponize their power as officers of the court and to target and bully other people. We also believe that judges should be trained specifically about the tools that they have to be able to address this behavior. The commission does trainings like this with judges, and so I've been able to present on this data to judges, and judges have been very receptive to being able to use their power. But again, they want to know, what specifically should I say? How do I intervene if I see someone belittling their opponent in court? How do I do that in a way that doesn't get challenged and overturned on appeal? The next one deals with law schools. Law schools should offer training so that students learn that they may face this kind of behavior in the workplace, but that it's not acceptable. I would hate for people to enter the legal profession and think, well, that's just what you have to do to be a good lawyer, to be able to advocate for your client. I would submit that if you're the kind of person who has to denigrate other people to be able to advocate for your client, you're not a very good lawyer at all. to me, that's a sign of weakness. And so I really want to commend this law school for having a center that provides this kind of education. You were the very first law school to reach out to me when this report was released to say, would you come talk about this topic? And then when I read about the center and this lecture series, I thought, of course, these are the kind of values that they have here. This is the kind of culture that they are fostering. So I just want to thank you again for that, because you're doing this as a law school, this recommendation. Bar associations should use their reach to be able to work with their members. At the end of next month, I'll be speaking with the report's authors at the Philadelphia Bar Association on this topic, and we're really grateful for the opportunity to engage. And then as it relates to what do you do as an individual who is being bullied, that was one that we really thought long and hard about, because there are certain things that you can do. You can, of course, document. You can, of course, report. But I was wanting to be really realistic. That fear of being retaliated against, that feeling of, am I really good enough? That fear of being perceived as weak is real, and worrying about the repercussions. And so we recommend that people do what they think best protects their safety, their physical career. But bullying is not going to be challenged as a profession by expecting those who are already being targeted to do the heavy lifting of trying to figure out how to shift the power dynamics. It will only be changed when people who have the power and the influence choose to use it for good. And this quote up there really expresses our belief that those in power in courts, in firms, they have to be the ones to take action. It's not going to be the people who are actually being subject to it. And I want to share these quotes before we take some questions. What we found was that there was a real desire to see change. But people recognized that unless there are consequences, there won't be change. And so there has to be a sense that we're not just going to accept these as the norms of our profession. We're not just going to write it off as, quote, zealous advocacy. We're going to decide that as officers of the court, as people who are in a profession that are supposed to uphold equal protection of the laws, due process, to make sure people are treated equally and fairly. We cannot do that and promote that as a profession if those are not the virtues that we live by and exhibit with each other. I have a few more comments, but I want to make sure that we allow time for questions. And so we're going to give you an opportunity to be able to run around. So if you have questions, please feel free to raise your hand.
I have two questions. My first is if you could remind me of the total raw number of participants that you had in your program or study. The second being what steps you took to protect the anonymity of your participants through the duration of your study.
Great questions. We had 6,010 people who submitted responses. And the people who actually did the research, they could provide more information on the methodology. But it was all sent anonymously to people. And we did not even provide any place where people could put identifying information because we wanted people to feel fully protected in revealing information. And we also did not want any particular entity to be able to go back and to kind of aggregate information and to be able to identify. And then when we did the focus groups, people had to sign confidentiality waivers. And then at the end of the conclusion of the study, our contract with the consulting group requires the destruction of those materials so that they can't be used at any other point. But being able to preserve people's confidentiality and anonymity was really important to us because we found that without that, people would not have been willing to share their information. What was also interesting was that over 2,000 of the lawyers who filled out the survey, they did take time to write some of the comments. And it was a large number of people, and people spent a lot of time writing because it seemed like it was one of the few opportunities that they had to be able to share things that were deeply personal and private.
Is there a place that we can go to find model anti-bullying language that we can incorporate into a policy for a law firm or other uses?
That is something we are still working on in collaboration with bar associations. We were debating whether to include it as part of the report itself, but we ended up not including model policies as part of the report because we thought there would be so many variations that would be relevant. But that's something that we're working on now in collaboration with bar associations and hope to soon make those available on our website. But if you're part of a bar association, that's a great initiative to engage in for organizations to talk through some of the things that are specific to their jurisdiction and to kind of leverage the labor and employment expertise of some of the people who are part of those associations. And so we're aware of some bar associations who have already taken the lead on doing that.
Was there any indication that designated DEI programs in a firm reduce the amount of bullying?
That was not one of the issues that we looked at. We looked at just people's demographic characteristics, and they had the choice of whether or not they wanted to provide that information. And then we were just focusing on people's experience. So we did not ask questions that would be specific to their legal environment or legal firm. But there are lots of things now that I would love to be able to research, follow-up questions, because I think once we saw the results and we didn't know what they would be, it does raise a lot of other questions about what are other ways that we might be able to address this. Another area where I wish we were able to do some more research would be looking at impact on staff, because lawyers are only a part of the legal profession. You have paralegals, you have support staff that they have even less power within legal organizations. And from anecdotally, I would expect there would be a lot of bullying that would be experienced there, but we didn't get to that question either.
You referenced a judge that was updating his or her standing order with some language. Is that available?
I'm going to follow up with that judge to see if they would be willing to make it available, because I know they're really passionate about this, and I'm trying to think of a way. We would post it, but if you could follow up with me, like I could give you my contact information after this, I'd be able to let you know if they are willing to make it available.
Hi. It struck me that the largest group of respondents reported opposing counsel doing the bullying. Specifically, I was thinking in the context of a negotiation when, intimidation is used very commonly as a tactic. How do you recommend that bullying be policed in an environment like that? Or is there an acceptable line that should be set that shouldn't be crossed? And is it on each firm to kind of police their own lawyers on their own side, or do you expect opposing counsel to kind of police each other?
It's a great question. And I think actually the areas where it's hardest are the workplace, your own colleagues. The area where I think there are the most opportunities is in the context of a courtroom, because you have a judge, and there are several rules of professional conduct that would encompass some of that behavior. And so I do not think it's the job of firms solely to police their attorneys. I think they should. I think they should absolutely say, if you're going to work here, there's a certain standard of professionalism that we expect. But I do think that judges should be proactive when they see this kind of behavior happening in the courtroom. I mean, I think many people who have been here, who have practiced, you've had experiences where you're getting talked over during a hearing. You are having people make belittling, condescending comments. Judges have the power to say that behavior violates the rules of professional conduct because it's obstructing these courtroom proceedings, and you're not allowed to do that. I train with a judge on the different tools that judges have. But in terms of, if we use a deposition, for example, because that's a place where a lot of bullying happens. What I chose to do in experiences like that when I was practicing, first of all, I would have all of my list of objections there, so I had the rules ready. And that was important because when people are bullying you, it can cause your heart to start racing more quickly. You're not able to think as clearly because the emotion that's associated with being targeted comes upon you. So being able to know exactly what rule the person's behavior is violating, that empowers you to be able to object in real time. Also, making a conscious effort to put on the record nonverbal bullying that's happening is really important, because some lawyers are very skilled at kind of avoiding being detected by hovering over somebody, intimidating, things that may not necessarily show up on a court reporter's transcript. So they may not actually say insults that would be obvious, but they might hover. And so a lawyer can say, I want the record to reflect that opposing counsel is hovering over me and refuses to step back. For things that are very contentious, there is the ability to have the deposition video recorded, because that actually diminishes a lot of bad behavior, and having a judge ready so that you can reach out and make objections in real time if a person is obstructing. But I think a lawyer who's being targeted in those environments should absolutely stand up for themselves if they feel that they can safe in doing so. I'm always hesitant in saying you must do this because people react to conflict and to bullying differently. But I think that there are a lot of tools that are at your disposal in the context of a negotiation or opposing counsel. The last thing I would say is, I do think if people feel empowered to say no, they should. I had a scenario where I was negotiating something, and opposing counsel was screaming at me on the phone, yelling profanity, and being really belligerent. And there came a point when I said, you're not going to talk to me this way. This conversation is going to end unless you speak to me in a respectful way. Otherwise, our communications regarding this case are going to happen in writing. So I wasn't saying I refused to engage and advocate for my client, but I was saying I'm not going to just allow you to berate me and treat me in an unprofessional manner. And then there are rules of professional conduct. If people's behavior rise to a certain level, it would violate certain rules of professional conduct, and complaints should be made to disciplinary commissions. I think there was one question right up here.
I'll get there in just 1 second. I do want to follow up on what you just said, though. We've talked a little bit about some of the policies that might make sense to change, either for judges or for law firms. Do you think that the current rules, at least the model rules, are adequate?
So because we're a court entity, I can't tell you what I think should exist, but I can tell you that the current rules don't encompass all behavior that I would say is bullying. So the current rules focus on protected characteristics, and those rules may not give people the ability to address some of this behavior. And those rules often apply in the context of litigation or court proceedings. They may not apply to circumstances where it's within someone's own firm. So I can't tell you whether I think they should be changed, but I can tell you that they are insufficient to address the behavior that I think is unacceptable.
Head this way, and then it's about... That's okay, I'm here.
Speaking of protected characteristics, sometimes the definition of exactly what that is, or the list of what that is made during different times. Like if you go back in history, sometimes sexism wouldn't be a protected characteristic, ageism wouldn't, et cetera, et cetera. So for this time with this study, do you have a list of protected characteristics, or do you have a definition that then you pose onto what you're reviewing?
That's an excellent question. So the protected characteristics would be based on state law. And so it's based on whatever the state law determines those categories are. Those may be different in each state, but in Illinois, for example, the protected characteristics would be included in the Illinois Rules of Professional Conduct. But to your point, the reason why you're targeted shouldn't be the basis of whether you have a remedy or not. It really should be whether you're being targeted at all. And so that was one of the reasons why I thought it was so important to look at this behavior that would fall outside of protected characteristics, because that does not encompass the full scope of objectionable behavior.
Hi, so first, thank you so much for your great lecture. I think my dad would have actually really enjoyed listening to it.
Thank you.
But I do have a question. And I had two questions. I think the second one you're probably going to say you can't answer because it relates to what other people were talking about, which was about addressing bullying and whether you think, as one of the recommendations, there should be advocacy to amend, expand the rules of professional responsibility to overtly include bullying, and similarly legislative advocacy to expand, civil rights laws beyond just what's a protected class to include bullying. You're probably going to say you can't answer that. So I'll focus on the other question, which is, as opposed to, separate and apart, and in addition to addressing bullying, sort of the prevention piece, ways to prevent bullying from ever occurring, sort of looking further upstream. Mm-hmm. And my question, specifically, I know you talked about anti-bullying training, sort of creating the professional norm that we don't do that. Have there been any studies or research around what makes bullies bully? Right, and sort of addressing, I know there's a lot of focus now in legal education around, developing professional identity and mental health. And is there anything that we could do in law school as we're training the future generations of lawyers, separate from bullying training, to equip law students with skills that might prevent bullying behavior, which I have to think connect to mental health a lot?
Absolutely. And it's funny you raised the issue of why do people bully, because I was trying to do some personal research on that in the past couple of weeks, because to my knowledge, there's not that research as it relates to the legal profession specifically. But as it relates to workplace bullying as a whole, research has been done, and it's a spectrum of reasons. So some people bully out of insecurity and low self-esteem. But conversely, some people bully because they have an inflated sense of self and a sense of narcissism. There are some people who bully because they sort of enjoy targeting other people. And then there are others who bully because they may not necessarily have the skill set to know how to navigate a circumstance. This is not research-oriented, but this is an anecdote. I had a partner of a large firm come up to me after he took the bullying study, and he said, as I was taking the study, I started realizing that I had to answer yes to a lot of the behavior when it asked, have you ever bullied someone? And he said it was sobering because I didn't think of myself that way. He said, but then as I was thinking about how I treated people, he said he recalled sitting in his office, finding out an associate had missed a deadline, and going into that associate's office and screaming and standing over the desk. And he said, I knew that his wife was on the phone on the other end.